and gentlemen, our esteemed viewers at home. Welcome to another edition of Democracy and the Rule of Law, a show where we delve deep into the critical issues of law, politics, and governance. In today's episode, we will be looking at the issue surrounding the recent appeal court judgment nullifying the judgment on Rivers State local government election. Of course, we're all inundated when the Federal High Court gave judgment instructing the Independent Electoral Commission (INEC), to halt the release of the voters' register to the Rivers State Independent Electoral Commission. And also, of course, there was an outcry when the same court also instructed security agencies not to supervise the election. Of course, several legal commentators, public affairs analysts, they had a lot to say. Some had insinuated that the court lacks jurisdiction to restrict the Nigerian police force from performing their constitutional duties. And also, some also, of course, raised the issue that it is within the jurisdiction of the states, to preside over local government election. Of course, that issue has now been laid to rest by the appeal courts, by virtue of this decision. So we'll be looking at all of that, and also the fact that, of course, the aggrieved party still reserves the right to appeal to the Supreme Court. Also, we'll also be looking at the issue concerning the sack of the Code of Conduct Tribunal chairman, of course, by the Senate this week. Of course, the Senate have cited issue of conduct unbecoming of judicial officers, issues of corruption, and so many other issues that have led to that sack. Of course, they relied on the relevant provisions of the Constitution. So many people have criticized that, and so many people have also applauded, that decision. We'll also be looking at that, and if we have time, we will also take a cursory look at the Senate approval of life imprisonment penalty for drug offenders. These are the topics we'll be looking at for today's episode. We'll go on a very short break, and when we return, we'll introduce our guests who are already seated in the studio this evening. I remain your presenter, Barrister Kenneth Mimo. Stay tuned. We'll be back very shortly. Welcome back. If you are just joining us, you're on to your favorite program, Democracy and the Rule of Law. With me on this episode is Barrister Obiora Ume. Barrister Obiora Ume, welcome you to the show this evening.
Thank you very much, and good evening to our esteemed viewers.
All right. Without much ado, we would delve into the nitty-gritty of today's topics. So the first topic is we're looking at the issue, concerning the sack of the Code of Conduct Tribunal chairman. So many people have raised eyebrow concerning that sack, whether it's in line with the relevant provisions of the Constitution, and also asking whether it wouldn't have been proper, for the NJC to intervene, given the fact that it has to do with an organ of government separate from the judiciary. So some people have raised that issue. So what do you have to say concerning the issue surrounding that sack and the constitutional or legality of that process?
Thank you very much. We have been invited with the issues concerning the sack of the Code of Conduct Tribunal chairman and how the thing has kind of hit constitutional roadblock. What we have seen so far shows that the Senate did not appear to have properly done its own work before embarking on that mission. Let's look at it clearly. First, the alleged sacking was based on allegations of bribery and corruption. And then, on his part, Danlad Umar, the CCT chairman who was involved in the embargo, has come out to say that by two letters issued to him by the EFCC, during the time that Ibrahim Lamothe and Abraham Magu were the chairman of EFCC. They issued him 2 letters, one dated March 5, 2015, and another dated April 20, 2016, showing, clearing him of the allegations of bribery and corruption. And at some time in 2018, the Attorney General of the Federation, was worried and criticized the EFCC for trying to revive the charges or the allegations against someone who had been cleared. That is on one part, but that is not the center of the controversy. The real issue in controversy is that the Senate single-handedly proceeded to remove Danlad Omar as the chairman of the Code of Conduct Tribunal based on the provisions of Section 157 of the Constitution. And then, looking at Section 157, it does not cover the office of the chairman of the Code of Conduct Tribunal, because that office is a judicial office. Section 157 deals exclusively with executive bodies like the Code of Conduct Bureau. Now, if you want to remove the chairman of the Code of Conduct Bureau, it's covered by the provisions of Section 157 of the 1999 Constitution as amended. And that does not relate to the chairman of the tribunal, which is a judicial office. And of course, we know by virtue of the provision of the Constitution that makes room for separation of powers. Executive offices are separate from judicial offices. And the issue is that by clear provisions of the Constitution, it is the 5th schedule that concerns the removal of the chairman of the Code of Conduct Tribunal. And what that section clearly provides for is that the president cannot remove the chairman of the Code of Conduct Tribunal except with an address supported by 2/3 majority of each house of the National Assembly. What that means is that being a judicial officer, that the Constitution has provided the modality for his removal. Of course, he can be removed, but what we are saying is that due process must be followed. That is the whole essence of the rule of law. If the Constitution has made provision that he can only be removed via an address of the president supported by 2/3 majority of the Senate and House of Representatives, then it is irregular. It's unconstitutional for only the Senate to embark on such a mission. And that is why, experts, legal experts have come up to say that it is already hitting a constitutional roadblock.
Okay. Of course, the Senate has based their decision on Section 157, Sub 1 of the 1999 Constitution.
Yes, I've just said that is the anchor of the Senate.
Yeah.
But the Constitution has said that...
Is it that they are mistaking the Code of Conduct Bureau? Is there a difference between the Code of Conduct Bureau and Code of Conduct Tribunal? Because perhaps they are mixing it, or the view that those two offices...
That's a misinterpretation.
Because all of them has code in it.
That is causing the confusion. The Code of Conduct Bureau is an executive body which is governed by the provisions of Section 157 of the 1999 Constitution as amended. But when it comes to the tribunal is, as is indicated, a judicial body. And because it's a judicial body, it is the first schedule of the 1999 Constitution that makes provision on how the chairman of that body can be removed, being a judicial officer. And of course, the Senate made 3 wrong steps. The first one is trying to remove him through the provisions of Section 157, when that governs only the Code of Conduct Bureau, being an executive body. Now, the tribunal itself is a judicial body, governed by the fifth schedule of the Constitution. That's one. Two, because the Constitution has made clear provisions on how this man can be removed. Taking steps to remove him without complying with the clear provisions of the Constitution is wrong and unconstitutional. We are saying that let the clear provisions of the Constitution be complied with. And so long as it is not complied with, whatever has been done or purportedly done is irregular, is unconstitutional, is null and void. Now, the Senate also has gone ahead to purport to appoint someone to take over, one Bello to take over from Omar. And then there's still another issue there. First, the issue of the removal of Danlad Omar has not been properly done. And what that portends is that he is still there as the chairman of the CCT. That's one. Two, the person that has been recommended by the Senate to take over, Mr. Bello, does not appear to qualify. Because the Constitution says that the person who will take the office of the chairman of the Code of Conduct Tribunal must be someone who is qualified to sit as a judge of a superior court of records. But then the person who was recommended is an accountant who ordinarily, an accountant is ordinarily not qualified to sit as a judge of a superior court of records. He has qualifications as an accountant and forensic experts and all that. Does that qualify him to sit as a judge of a superior court of record? The answer is no. That is the other thing. And then the claims by Mr. Umar that had been cleared, if, as he has said, as told the world, that had been cleared of the bribery allegations and corruptions, and that that what is going on is that he's been witch hunted, that has handled serious profile cases involving corruption, involving top people in society, including governors, judges and others, that actually he does not deserve what he appears to be getting. But that is not the issue for discussion. The issue for discussion is, has the proper steps for his removal been taken? The answer is no.
Yeah, but I want to inquire if it is within the duties of the Senate to appoint a court, because if the Constitution actually gives them that right to appoint, then they also have the right to fire.
He said, we are dealing not with the appointment of the chairman of
they have
tribunal.
I get another one. They have got
what is an issue now?
Recommended a replacement.
Removal.
Yes.
Removal. That is what is an issue, not appointment.
Yeah, but who appoints the Code of Conduct Tribunal chairman?
Now, the president does that on the recommendation of the approval of the president recommends to the Senate, and then the Senate confirms and appoints. But of course, the issue is clearly stated that when the issue of removal of the chairman of the Code of Conduct Tribunal is to be effected, the Constitution has laid down the procedure for that. And what does the Constitution say? That the president will address the National Assembly, and that for that chairman to be effectively and constitutionally removed, there must be an approval of that address of the president by today's majority of the Senate and House of Representatives. Now, since in connection with Danladi Omar's purported removal, it was only the Senate that embarked on it, the constitutional requirements have not been complied with. It doesn't matter that the president wanted him removed. It does not matter. Even if the appointment is done by Senate or the president or both of them, so long as the Constitution has laid down the clear procedure for the removal of the chairman of the Code of Conduct Tribunal, then the Senate must retrace its steps, go back to the drawing board. And this is really getting, you know, some backlashes from constitutional experts, even some senior advocates have said that it's embarrassing for the Senate to make this kind of mistake at this age of our constitutional democracy. And how can the Senate, you know, attempt to remove someone who ordinarily not supposed to be removed by the Senate alone, going by the clear provisions of the Constitution? And that actually, you know, is a sign that the Senate needs to go back and ensure that things like this do not occur in future. Because what it simply means is that the Senate did not properly interpret the clear provisions of Section 157 of the Constitution vis-a-vis the fifth schedule. And there's also a misconception which tends to confuse the Code of Conduct Bureau and Code of Conduct Tribunal. The Bureau is an executive body that can be dealt with administratively. If you were to be just the CCB, Senate can do whatever they want to do on that alone. But so long as it has to do with the tribunal, which is a judicial body, and the Constitution has laid the procedure for the removal of the chairman of that tribunal, that procedure must be strictly followed.
Okay. With the alleged non-compliance with this procedure, what would you advise constitutionally for this purported removed chairman to do? Is he going to stay back in his position since the alleged removal didn't follow due process, or does he need to vacate and then fight his case in court?
The answer is clear. The attempt at his removal hits constitutional roadblock. What that means is that he has not been removed effectively.
Oh.
And because he has not been removed, he is still there until he is duly removed in clear compliance with the clear provisions of the Constitution. The Constitution is the ground law, it's the organic law, it is the highest law in this country. And any action taken or purportedly taken that is not in clear compliance with the provisions of the Constitution is null and void, ab initio.
Should he not go going to court to get the interpretation of the? Should he not vacate first, then go to court?
Now, you see, vacate on what grounds? On grounds of an unconstitutional act? The body that is supposed to remove him comprise of the President, the Senate, and the House of Representatives, where the tripartite body did not join in the purported removal. You and I know that the constitutional provision has not been complied with. And you and I know that the Supreme Court has seen a number of cases where that unconstitutional acts are null and void. And if something is null and void, it shows that as far as the law is concerned, it does not exist. And you know, because you cannot place something on nothing. Like the Reverend Lord Denning, you know, he said the Macquarie USC. You can't place something on nothing and expect it to remain. It will naturally collapse. If you are now saying that a man should now exit and go and start fighting his case in court, whereas the issue is that he has not been duly removed in clear compliance with the Constitution. And there's also another, you know, danger there. And what is that danger? The failure to distinguish between the Bureau and the Tribunal made the Senate even to purport to appoint a replacement, someone who does not possess the requisite qualifications. Because an accountant who may have very good knowledge in forensic accounting and all that, that does not qualify him to take over the chairmanship of the Code of Conduct Tribunal, because the Constitution said that such a person must possess the qualification of a judge of a superior court of record. Now you look at it, nature holds a vacuum. Now, what the Senate is supposed to do is to go back and put the acts in order, and then first look at it from the point of view of the man who has been at the center of the controversy. Were there letters written in March 2015, precisely 5th of March 2015, and 20th of April 2016, clearing this man of the bribery and corruption allegations? Because you will know that the purported removal was anchored on allegations of bribery and corruption, and it was subject to investigation by the EFCC. If the anti-graft body eventually came up with letters clearing him of the bribery allegations and corruption allegations, it means that the premise on the basis of which he was to be removed is hollow. It's baseless. Because if the anti-graft agency has said, look, we got petitions, we investigated this man, and at the end of our investigations, we came up with the findings that the man did not do what he was alleged to have done. Then the Senate and whoever going ahead to take steps to remove him on the basis of the same allegations, it will look like the man is being witch hunted. Particularly with the reminder that sometime in 2018, the Attorney General of the Federation lambasted the EFCC for attempting to revive the charges against the same man that they have written letters of clearance without justification. Of course, if there are fresh evidences or fresh charges coming up against him, not the ones he has been cleared with, of course, the rules of natural justice, they still demands that this man should be given an opportunity to be heard before findings and conclusions are made that affects his rights and interests as a person.
All right. Given the humongous amount that the Senate got from the National Treasury, with the number of aids, both legal, financial, and otherwise, that is at their disposal, and making such, of course, an obvious mistake, constitutional mistake, will you regard this as a little bit of an embarrassment?
Yes, I've already said that it's quite embarrassing to the nation, at this age in our constitutional democracy. And I've already said that they must ensure that such a thing do not occur. Of course,
will you regard it as a stroke of genius? Probably they have discovered an angle of the constitution that we are not looking at, which has given them the power. Probably it was a stroke of genius.
You see, it is not the Senate that tells Nigerians what should be done. It is the Constitution, which is the compass that determines what should be done and how it is to be done. The Senate is there. The Senate came up with, with a resolution purportedly removing the chairman of the Code of Conduct Tribunal, whereas the Constitution has equally made provisions on how that man can be constitutionally, effectively, and validly removed. So long as the Senate has goofed as far as the removal of this man is concerned, it is not a mark of genius. Rather, the Senate will be telling Nigerians, sorry, we made mistake. And of course, nobody's above mistake. We'll go back to the drawing board. And like I said earlier, going back to the drawing board requires the Senate, first of all, looking at the matter again with an eagle's eye. Is this man actually having current allegations against him of bribery and corruption that are yet to be cleared? And if there are such allegations, has he been given opportunity to respond, to be heard on those allegations? When that is done and they have come to the conclusion that he must be removed, then the proper procedure, and that's the whole essence of democracy and rule of law. Let the law prevail, not the whims and caprices of any man or woman. The man tends to, claim that he's being witch hunted because he handled profile cases against very high, personalities in the nation, including the immediate past, the embattled CJN, whose case was finally resolved through settlement and so on, or Sylvester Onoren, yes. Then past governors, members of the National Assembly, and so on. So he is giving an impression that because he had given judgment, decisions, and so on, that may have affected some highly placed individuals in Nigeria, that he is being unjustifiably attacked. I am not holding for.
Yeah, but even at that,
standing for him. All I'm saying is that
need to be followed.
If there are allegations against him, and there are evidences of those allegations, then let the proper procedure for his removal be taken.
Okay.
But if there are no allegations, or if the allegations are based on the word that he claims to have been clearly cleared by the EFCC that investigated those allegations, then on what basis now will the same man be made to be removed because of allegations of which he has been cleared, except they are saying that the letters of clearance from the EFCC are not enough clearance. So as far as the matter is concerned, there is need for the Senate to go back to the drawing board. It's embarrassing.
And also you are submitting that as far as the Constitution is concerned, the man remains.
Of course, it remains.
Chairman. The removal of the EFCC is not avoid that being an issue. That's what you submitted.
So that his removal
is not avoid.
It's not avoid. It's unconstitutional. The Constitution has set out clear steps that must be taken for him to be removed. So his purported removal, having not been in tandem with the clear provisions of the Constitution, remains null and void and of no effect. And what that means is that as far as the law is concerned, he has not been removed and he remains there. Then when it's properly removed, he packs his bag and baggages and go. And then until that time, he still remains there.
Wouldn't that be a constitutional logjam? Because we see that even when a constitutional provision has not been followed, we saw that in the removal of the deputy governor of Edo State, the constitution was not followed. He was removed unconstitutionally. He has to leave. Somebody has to be appointed. Then later on, he went to court and the court returned him. So shouldn't it be the procedure?
No. You see, there are different strokes for different faults. What we canvass, what we advocate, and what we know is that whatever that is to be done must be done in clear compliance with the Constitution. That of Edo State is not on all fours with this. In Edo State, we saw a situation where the then governor of Edo State and the deputy were at, daggers drawn. They were not, at that point in time, working together. In fact, we also, when the governor had to remove the office of the district to somewhere else, but we learned that where he was moved to, there were no lights and so on, and the man decided to manage in that place. And then the governor, because of the powers he wielded as governor at that time, decided to do away with him. And then they did certain things that were unconstitutional, and they replaced him. Now, when that happened, he felt that there was no point dragging, that the best bet was for him to approach the court, that the procedure for his impeachment, for his removal, were not followed. And that the allegations made that on the basis of which he was purportedly, removed, were not substantiated. They say because in that of Edo State, they made allegations against him, the deputy governor, and it was on that basis he was removed. He went to court, and the court said his purported removal was not allowed in effect. In that case, the body that purportedly removed him had the powers to remove him. But the evidence on the basis of which they acted was not sufficient for his removal. In this case, we are looking at a scenario where the body that is purporting to remove Danladi Umaru does not have the legal capacity to remove. There are two different things, and because there are two different things, it is not analogous to say that, well, in the case of Deputy Governor of Edo State, the man went to court and was eventually restored. Yes, in Edo State, the Deputy Governor was removed by the authority that had the power to remove, but there were no sufficient grounds for his removal. And in the case of Danladi, we are saying that the Senate alone, or the Senate and the President alone, cannot remove him. The Constitution has said, before you remove this man, you must have an address to the President and the support or the approval of the two-thirds majority of the Senate and House of Representatives.
Right.
And there's no way they can jump over that. And because the constitutional provision, anything done not in clear compliance with that provision is null and void.
All right. This is where I will take a short break, and when we return, I will look at the second topic for today's edition. Stay tuned. We will be back shortly.